Dear colleague, welcome to the training on personal data protection. On this training, we will take you on the road to data protection compliance. On this road, we will have 3 stops. On our first stop, we will help you detect personal data in your daily work activities. On our second stop, we will take you through the general principles which must be applied when processing personal data. On our third stop, we will explain how you can protect personal data. And after these 3 stops, you will hopefully understand your role in protecting personal information and why this is important for our company in demonstrating compliance with the rules and regulation on personal data protection. Before we get started, please make sure you have our corporate manual on personal data protection called The Road to Data Protection Compliance right beside you to keep you on track in case you get lost. So, let's start our ride. We are now on our first stop. Let's take a look at what information of all the data that you process in your daily work activities is considered as personal data. Well, by definition, personal data is an information or a combination of information that can identify an individual. To simplify a bit, it can be just one information, such as personal ID number or biometric data, fingerprint, etc., or different pieces of information, where each information separately doesn't identify a person, but a combination of information can identify a particular person. For example, if I just say, well, I know a John who works in a pharmaceutical company. This information identifies nobody. There are many pharmaceutical companies, and there are also many Johns out there as well, right? However, if I add that this John is a head of sales in a company called Alkaloid Skopje, and to avoid duplication, I also add John's personal business contact, telephone number. Well, this combination of information will lead to the identification of a particular John, John Blue, an identifiable person, meaning I am processing John's personal data. In practice, most of personal information that you process in your daily work activities will be different pieces of personal information. What is also important when detecting personal data is that it doesn't matter who can identify a person. What matters is that it is possible to identify an individual. Let's look at an example. You receive a message from your colleague. 007 has called in sick. To you, this information is nothing. You do not know who 007 is, you just need, for some reason, to add this information to your records. So, you might think, well, I am not processing personal information, as I have no idea who 007 is, and I do not even care. However, somebody knows what this 007 stands for, or who 007 is, meaning that you are processing personal data. It is just protected with masking as a data security measure. Masking is a very good, advanced protection measure. That is why it is often used for protection of special categories of personal data. And that brings us to our next important issue when detecting personal data, and that is detecting sensitive personal data. So, what data is considered as sensitive personal information? Any data related to health or private life, trade union membership, genetic data, biometric data, person's sex life or sexual orientation, race, ethnicity, political views, religious or philosophical beliefs, criminal record. What is so special about this category of personal data compared to other personal data? Well, processing of sensitive personal information is allowed only in special circumstances imposed by the law, and if allowed, advanced protection measures should be or must be applied, such as masking, encryption, special care when this data is shared, and so on. So, be aware of sensitive personal data and make sure you detect sensitive data among personal information that you process. What you also need to be aware of when detecting personal information is that, due to technological changes, the definition of personal data changes all the time. What this means in practice is that it's very likely to happen that information that you would not even consider as personal is actually personal data. For example, IP address, location data, your online ID, and so on. These information are considered as personal information, not only by interpretation, but by legislative definition of personal data. But let's be honest, how many of us have even thought about categorizing the type of these sorts of data? Not many, I'm sure. So, to be on the safe side when detecting personal information, always consult your legal officer or local data protection officer if you are in doubt. Before we move on to our second stop, we also need to explain what processing is. Simply said, data processing is everything you do with data. There are various activities that count as processing, such as collecting and arranging information. For example, organizing records of employees or business partners' contact persons, preparation of documents containing personal data, posting a photo of a person on a website or any other media, sharing data with others, your colleagues or people outside the company, destruction of data, deleting computer files, shredding documents, video recording and video surveillance, print screens of people on web meetings, seeking advice from an expert which involves discussing personal data, and so on. Don't get confused by common misperception that you have to see the information in order to be processing personal data. For example, storing information, physically or in electronic form. It also means processing of personal data. So, even if you just store information data and you do not see it because you do not need to see it, you are still processing personal data because you are in charge of storing data. We could go on and on in listing activities that are considered as processing personal data, but in short, everything counts and needs careful approach. A useful advice: if you are not sure whether you are processing personal data, always consult your legal officer or local data protection officer. Now that we have detected personal data, it's time for our second stop: understanding the general principles of data processing. Before we start processing personal data, we first need to make sure that we will do this the right way. Here are 7 questions that you need to answer before you start processing personal information. Your answers will help you determine whether your intentions are in line with general principles of data protection. These general principles are obligatory. They are imposed by the law, so you have to make sure that your processing activities are always in line with these principles. So, let's take a closer look at what these principles are. First 3 principles, which are closely connected to each other, are lawful, fair, and transparent processing. What is lawfulness? For processing of personal data to be lawful, you need to identify specific grounds for the processing. This is called a lawful basis for processing, and there are 6 lawful bases. They depend on your purpose and your relationship with the individual. Let's take a quick look at the 4 most common legal bases for processing. Legal obligation of controller. Here, the purpose of the company who will process data is imposed by the law. An example: in order to obtain Social Security cover, the law obliges your employer, controller in this case, to provide your personal data to the relevant authority, for example, your weekly income. This obligation of data processing, disclosure, and sharing is obligatory for the employer. It is imposed by the law. The employer doesn't have a choice of not processing this data, and also you as an employee do not have a choice to prevent such processing. On the contrary, when there is no legal obligation of the controller, individuals whose data you want to process have a choice. They have a right to decide if they allow you, your company, to process their personal data and to what extent. And in such case, your processing depends on individuals' consent to your purpose of processing. For example, you as a company want to promote your product via email of individuals. There is no law that obliges you to do that, so in order for your processing to be lawful, you need to obtain individuals' explicit informed consent for such marketing. If they don't agree, provide consent, you are not allowed to process their data, as they have chosen not to allow you to do so. Another legal basis that depends on personal choice is a contract between you and individuals. For example, you as a company sell goods online. You have entered into a contract with an individual who has ordered your goods. He or she has made a choice. So based on that contract, you are allowed to process the name, delivery address, credit card number, and so on, because this is necessary in order for your client to receive the goods they ordered based on the contract. An interesting but quite tricky legal ground is legitimate interest of a company. This legal ground allows you to process the data which you really need to process in order to fulfill an interest that you are following. But you are allowed to do so only after having checked that the fundamental rights and freedoms of the person whose data you're processing aren't seriously impacted. For example, your employer has decided to ensure its network security by monitoring the use of its employees' IT devices. Your employer may legitimately process personal data for that purpose only if the least intrusive method is chosen as regards the privacy and data protection rights of employees. For example, he can only limit the access to certain websites. As you can see, it is not all that simple, which brings us back to our advice. If you are not sure, always consult your legal officer or local data protection officer, because if you do not have appropriate legal basis, your processing will be considered unlawful. What is fairness? Processing of personal data must always be fair. If any aspect of your processing is unfair, you will be in breach of this principle, even if you can show that you have a lawful basis for the processing. In general, fairness means that you should only handle personal data in ways that people would reasonably expect, and not use it in ways that have unjustified adverse effects on them. You need to stop and think, not just about how you can use personal data, but also about whether you even should. Assessing whether you are processing information fairly depends partly on how you obtain it. In particular, if anyone is deceived or misled when the personal data is obtained, then this is unlikely to be fair. What is transparency? Transparency is fundamentally linked to fairness. Transparent processing is about being clear, open, and honest with people from the start about who you are and how and why you use their personal data. Transparency is always important, but especially in situations where individuals have a choice about whether they wish to enter into a relationship with you. If individuals know at the outset what you will use their information for, they will be able to make an informed decision about whether to enter into a relationship, or perhaps to try to renegotiate the terms of that relationship. So in short, connect with individuals. Ensure that you tell people about your processing in a way that is easy to understand. To get an idea of how important these principles are, please press pause and read through some practical cases where non-compliance led to breach of data protection rules. Our next group of principles, which are closely connected to each other, are the following: purpose limitation, data minimization, accuracy, and storage limitation. What all these principles have in common is there is no place for the nice to have or just in case when it comes to data processing. Let's take a look at what this means in practice. Purpose limitation means that you must be clear from the outset why you're collecting personal data and what you intend to do with it, and you can only use personal data for that specified purposes. For example, if you have received consent from your client to use their email to send them information about a specific event, you are allowed to use their email just for that purpose. This means that you are not allowed to use this email for promoting your products, as the client has not been informed about that and has not given you their consent for promotion of your products. You need to obtain a separate consent, otherwise you are in breach of this principle. Data minimization means that you can collect and process only personal data that is necessary to fulfill that specified purpose. For example, if collecting emails of your clients is enough to fulfill your purpose of promoting your event, then you should not collect other personal data such as address of a client, because you do not need this data for this specific promotion. Your purpose can be fulfilled by just collecting emails. If you want to collect personal address, you will first need to justify for what purpose you need both email and personal address, otherwise you might be in breach of this principle. Accuracy means that you must ensure that personal data is accurate and up to date, and correct it if not. For example, if you have a record of clients, their emails, that you use for a specific purpose, and you haven't checked if all this data is correct in several years. For example, some clients have changed their emails, some have closed their email accounts, etc. Then you might be processing data that is not correct, and therefore you will be in breach of this principle. Our last principle of this section is closely connected to all the principles mentioned before. That is storage limitation. It means that you must ensure that personal data is stored for no longer than necessary for the purposes for which it was collected. For example, after you have finished your promotional campaign, promotion-specific event via email, you should delete data that you no longer need. To follow this principle correctly, you need to define how long you need to process data, not how long you want to process it, before you even start processing data. This need for storage must be justified somewhere, whether in your company local procedures or in the legislation. And remember, the general rule is data can only be stored for the shortest time possible. If anything is unclear regarding these 4 principles, as usual, we advise you to consult your legal officer or local data protection officer. To get an idea of how important these principles are, please press pause and read through some practical cases where non-compliance led to breach of data protection rules. We are now at our third stop. Here, we are going to take a look at the principle of integrity and confidentiality. This principle means that when you process data, you must install appropriate technical and organizational safeguards which will ensure the security of personal information. In practice, This means that you must use appropriate tools, methods, and technology to protect data against unauthorized or unlawful processing and to protect data against accidental loss, destruction, or damage. What security measure you will use or you can use depends on why and how you want to process data. In this regard, the most important recommendation that we can give you is make sure you comply with your company policies and procedures. Secondly, make sure that these policies and procedures are in line with the general principles of data protection. If not, we encourage you to make appropriate amendments. Let's take a look at a very simple example on how to manage data security. Let's say you are an HR officer and you store documents with personal data in your office closet. For example, folders of employees. Your purpose of processing is obvious, so we will not get into this, but we will analyze how you can protect this data. First of all, make sure you have control of who gets to access personal data and how. Make sure that only people who need to process data have access to it. In this regard, also make sure you use appropriate tools to prevent unauthorized access. Make sure that the closet can be locked. Lock it and make sure that only specific people who need to access this data, for example you and your deputy, have access to the key. When you leave your office, make sure you do not leave the document on your desk or computer screen. When you are requested to send some data to colleagues or authorities, mask the data that the recipient does not need. Masking, encrypting personal information wherever possible, is a very good protection measure to protect confidentiality of individuals, so use it whenever possible, but especially when you're sharing data with others and when you're sharing sensitive personal data. And finally, write all of these protection measures down into your procedural policies. This way, you will have clear instructions on how to act, and you will be able to prove compliance with the principle of integrity and confidentiality. For more practical advice on data security, please check Alkaloi's Manual on Data Protection and contact your local IT and data protection officer. What is also important in terms of data security is responsible sharing. Usually, you will not be the only recipient of the data that you are processing. You will be sharing this data with colleagues in your company, in your affiliated companies, with authorities, with partners. What you need to remember is that no matter who the recipient is, you must always comply with general principles of data protection. You need to make sure that your recipients are authorized to process the data you're sharing and that only necessary information is shared. When sharing information, make sure that good means of transferring data are used, such as masking data, special software for data protection, etc. Also note that the protection offered by the EU data protection legislation travels with the data, meaning that the rules protecting personal data continue to apply regardless of where the data lands, in EU or a third country. So remember to apply adequate protection when data is shared, hosted, or backed up outside the European Economic Area, because special EU rules on data transfer and protection apply. Also, be careful when outsourcing processing activities. Someone else may process personal data on your behalf. For example, you hire a telemarketing company. However, in such cases, make sure that appropriate agreements for data processing are in place between your company and your service provider. Why? Well, because you are still liable for data that is being processed on your behalf. And last, but not least, remember to immediately report any actual or potential breach of data security, because this is the only way to prevent greater damage. To get an idea of how important data security is, please press pause and read through some practical cases where non-compliance led to breach of data protection rules. And here we are. We made it to our final stop: accountability and compliance. The principle of accountability is a cornerstone of data protection. A business is responsible for complying with all data protection principles and is also responsible for demonstrating compliance. Therefore, it is very important for you not only to be aware of importance of data protection principles and rules, but to also understand importance of compliance and to actually comply with these rules. Being non-compliant could result in serious regulatory and financial fines for a company and its employees. During our previous slides, we have shown you actual real-life cases of companies who failed to prove compliance with data protection rules. On the next slide, we will show you how severe penalties for non-compliance can be, so take a look. Please, press pause and take a look. Dear colleague, you have made it to the end. We have finished our ride. If you have any questions or you need additional information, please contact your local legal officer or data protection officer. Thank you for listening, and until next time, remember, our reputation is in our own hands.